So we thought we'll keep it light this evening. It's been a long day. I know the sessions are running very late. We want to keep this conversation between Abhinav, who's a senior journalist with the Times of India. Our topic primarily is what is the role of legal journalism in the development of the law and in our judicial functioning, so in the functioning of our court systems. And Abhinav and I were talking about this earlier, that the Times of India, where he has been associated for almost 2 decades, now every morning has a column which is titled "In the Courts Today." This is a new development, and I've been at the bar myself for close to 27 or over 27 years practicing and otherwise. We didn't see this some years ago, Abhinav. So what could be the thought process that on the front page, in the first half of the page, which is kind of like prime real estate space, you have this "In the Courts Today" and a lot of developments?
So good evening, everyone. I'm Abhinav. I've been a legal journalist with Times of India for around 20 years. So I'll begin by answering what Satvik just asked. It actually shows how important legal... It actually shows how important legal news is becoming for the general reader. So everybody realizes now that courts are taking over more and more of our routine life, because there are so many PILs and so many petitions that people are filing, affecting every aspect of our lives. So our editors also saw that there was more readership for legal news. People wanted to know what are the latest cases going on in courts, what are the verdicts coming out, and based on the response that we got from readers. Also, one of the reasons is because even on television, we were seeing a lot of court coverage increasing. So, for example, when I started the Jessica Lal case, the acquittal happened. So that was one of the times when court reporting almost overnight shifted track. There were candlelight vigil and candlelight walks and protests. But what exactly was happening in court, why the accused got free, where were the mistakes made by the prosecution, all those issues we started writing. Before that, it was not that detailed, minute examination of each individual case. So then after that, the Nitish Katara case happened, and there was another one, Priyadarshini Mattu. So there were 3-4 cases where we did sustained reporting on the ground on the basis of court documents, which eventually led to each of the case resulting in a conviction in the High Court, and later it was upheld by the Supreme Court. So I think that was the moment when news organizations started realizing the importance of legal developments, court developments, and legal news. And now we are at a stage where I see not even one single, these drama series that come on OTT or on television, which don't have legal backdrop or court drama, as they say. So I think that is the reason.
Which is quite interesting, because in hearing your response, my thought is that it is bringing definitely justice to the end consumer of justice. So by reading a paper like yours, which has a huge circulation, or by following news on TV, the end consumer of justice is getting to know a lot more of what's happening, which is beautiful and much needed. It's also a reflection of how our society is evolving. But I also fear, as a practicing lawyer, that some of this, as we've seen in a recent case, sensationalizes an issue also beyond the proportions that it needs to. It sensationalizes an issue, it sensationalizes a case. I think Sushant Rajput was a good example. It's very, very unfortunate incident, but his girlfriend, I forget her name, Riya Chakravarti, that girl had to go through a media trial, and it just sort of sensationalizes the whole issue, which is why courts have had to then come in and say that we need to prevent against media trials. We need to prevent against the reporting of too much detail. There is something known as a sub judice rule, which means that if a matter is sub judice, you can't report about it in a manner beyond certain proportions, because then that could have or perhaps have a way of affecting the outcome. So I think, like everything in life, there's a pro and a con. In my personal view, I think the pros outweigh some of the cons that are bound to exist. I think it's good. But as we were discussing outside when we were waiting, some of this I think is also too much detail. For example, in the Saif Ali Khan case recently, there was so much media reportage that poor auto driver also was accosted and said, "Kya aapko bhada mila tha apni journey ka?" It's irrelevant. And we tend to lose focus. What are your thoughts on that?
No, absolutely. I think today we are in the age of live tweeting of court proceedings. We have constitution bench proceedings being put on YouTube. But for an average person who is, not a day-to-day litigant, I feel there's a degree of information that he or she deserves, and there's a degree or detail which he or she doesn't really deserve. For example, when we see these important constitution matters, so from the morning the channels and everybody starts flashing that the bench to assemble, the bench to assemble. Now everybody knows that the bench will assemble. So then there's the bench assembles, then they sit down, then the judge is writing or opening. So I believe this is where the role of a seasoned legal journalist comes into play. Because I remember, I'll give you one example of why this happens and how live tweeting can sometimes go wrong. So in this triple talaq case, I think it was 2017, it so happened that the Chief Justice of India gave the minority, but because he was CJI, he was the first to read out the verdict. So when he read out the verdict, everybody assumed that it is the CJI who's read out the verdict, so it has to be the verdict, and everybody ran out giving news that the triple talaq thing has been dismissed. But after the CJI, when the other judges, the 4 judges, I think it was 4 versus 3 or 3 versus 2. So other 3 judges, when they read the verdict, then it turned out that the ratio was actually opposite of what had been reported. So this is where you need seasoned, legal journalists who understand the nuance. And this is important also because many a times when you see it on TV, you are seeing one lawyer, being posed tough questions by the bench, and you feel that, oh, this poor fellow is in trouble and his case is gone. So it's not really like that. It's all about the context, all about the way in which the judges are asking questions, and most of the time what you see on these reels these YouTube reels and Insta reels about short, small hearings that happen in court. It's absolutely different from the eventual verdict that comes out, which is much more nuanced. So, for us journalists, also for those who are reporting on legal issues, I think it is important to realize that it can't be ball by ball commentary. That is where it leads to sensationalization sometimes, because a judge is asking some question and some probing query is put and he makes some remark which is obiter dicta, but you think that it is part of some ruling that he has given, and you end up misreporting. So the people get a different or unreasonable conclusion. And I will not say that the fault only lies with journalists, it's sometimes lawyer also. So initially, I'll give you one example. There was a lawyer who used to, 10 years back, he used to write to us that I'm filing a very important public interest litigation. He sent us petitions and every day used to send message. Eventually, when we went there, the hearing happened. So by the time it was supposed to happen and we were about to enter the courtroom, he came out. And he said that I have got an excellent order, you please report this. So I asked, your television people were there with the mic. So they asked, what is the order? So court said, either you withdraw or we impose cost. So that was the order. But I mean, people have to understand sometimes that even lawyers tend to sort of,
No, absolutely, and I think that brings me to, in your remark, I note 2 points that I want to highlight. One, the live reporting also from a lawyer's perspective and the exchange between the bar and the bench has a huge impact, because while courtroom is serious business, and while the courtroom is intended to have very, very serious exchange on propositions of law, sometimes there is a certain degree of bonhomie, an interaction between the bench and the bar, which allows for even the toughest decision to be taken with some degree of ease. But when you know that there is a certain amount of live reporting, and when you know that each word of what you're saying, then I think everyone in the courtroom gets very conscious. And, judges are also human beings, as a result of which, when they get so conscious, it affects that certain degree of exchange or ease of exchange, because you know that, if I say this to Abhinav, in this case, have I loosened the noose for him? It's not loosening the noose, it's just doing what's practical, because at the end of the day, the objective of the rule of law is that the judgment must be in a manner where it can be enforced. That's one point. The second point, I think, which is a very interesting point that you make with regard to the lack of sensationalization of cases, is that, I don't know how many of you know this, but under the Bar Council of India rules, full-time journalists have to suspend their legal licenses because the Bar Council rules do not allow for a full-time journalist to continue to hold their law degree. Now, that's a bit of a dichotomy, because on the one hand, the best person to decide on a case, or report on a case rather, is a lawyer who studied the law and can discern on what is the issue that is at hand in a case. Like he said in the Jessica Lal reporting, what are the flaws? What could the prosecution have presented? Having studied law, Abhinav knows what some of those issues are. Contrastingly, when the Bar Council says, no, you have to give that up, you can then fall prey to certain situations where the person who is reporting does not have that in-depth knowledge and is a pure journalist. Now, they may be very good as a journalist, but not every good chemist makes a good doctor, even though he knows what the salts are. And we need to be mindful of that. And it's something that I know came up very recently in the Mohammed Kamran case in December again. Are the legal beat journalists doing something about this? And after this, we'll move on to the law websites, which are playing a very instrumental role. But are, journalists of the print media doing something about this?
Yeah, so see, when I started, this beat happened as just a coincidence, and it was more of an accident that I got this beat. So when I started going to courts, I did not know the difference between a convict and accused or a witness, or I didn't know what is a charge sheet and what is a conviction, what is discharge. All that I learned on the job. So it takes time if you are a non-lawyer like I was. Eventually I did law, but yes, it takes time, and if you don't have supportive seniors, if you don't have vigilant editors, then mistakes can be made. And mistakes in legal reporting, the problem is that it's pretty tough. It's not like political reporting where you can conjecture, where you can speculate, or crime reporting where you can always blame the police that the police told us this. Here the problem is that it's on record, and then often the party which is affected by the mistake, then they take it before court, and then the court can also haul you up. So in that sense, yes, there has to be some kind of a legal background of most of the journalists who come or who report on these issues. But there's a flip side to it also, I feel. Sometimes when lawyers start reporting court proceedings, I personally have seen that they tend to become very technical. They see it as a court document or court order, that the proceeding has to be reported in that sense. So where I'll see that there's an underdog who has just maybe a legal aid lawyer, and he's still fighting a case, and on the other side is, say, a Mr. Mukul Rohatgi or a battery of senior lawyers. So I see that case with a lot of excitement, because this is a Goliath versus David show happening. But for a lawyer, perhaps it will not be that much, because he'll be more interested in what court craft the senior lawyers are showing. And is the judge able to manage between the two arguments? So are those of us like me who have who are essentially a journalist, who happen to cover legal beat, so our focus sometimes is also more on litigants. There are litigants like this Nitish Katara case. There was Neelam Katara, the mother who was every day coming to court, who was every day fighting off threats. So those are issues on which we like to focus. The other example is this Upahar case, in which the other Neelam Krishnamurthy was there. So I sometimes feel that in hardcore legal reporting, this streak of amateurism that sometimes is required in a profession like journalism, it goes missing. So that also happens sometimes with these the law website that we are talking about. The focus is only on the legal aspects, less on the human angle involved in it.
And I think you're right. I think I have to say that I am fairly biased towards the online legal websites. I think the online legal websites have been absolutely transformative for the advancement of the rule of law and our justice delivery system, largely, I would say. I think in a country like India, where lawyers continue to be restricted from advertising their wares, some of these online websites, by mere reporting of cases or reporting of deals, are able to conveniently bridge that gap where the advertisement barrier comes, is being able to be overcome. I also feel that similar to what the Chief Justice at the time, or Chief Justice of India had at the time said, that there should be live streaming of YouTube of all Constitution Bench cases, that because people all over the country can see it, because students in Kerala or in Mizoram or in Gujarat can see what's happening. Same way, I believe that this live reporting of cases on websites, because your Delhi paper will not probably reach Mizoram, but the website can be accessed. So it's able to bring to people all over the country information and news about either the Supreme Court, which is in Delhi, or about tribunals which are in Delhi, or about the commercial world and corporate transactions which tend to happen from Bombay or listing. So I think they have been a game changer in the industry. I think both of them are run in a very, very good way. They have great leadership. Again, all the people at the helm are lawyers and they're doing a great job. Yes, they've also been able to, at some level, educate the consumer. So I know for a fact from some of the pro bono work that I do, that a lot of senior citizen cases have been coming out in the last 1 or 2 years. And largely some of that is because of the fact that people read about a similar case and then they come and want to pursue their remedy. But you're right, I think they are more corporatized, if I may use that word, which is not a bad thing, but they're more corporatized and focused less on the person, but more on the problem. As opposed to perhaps the paper where, you know, the story of Neelam Krishnamurthy can come out.
Correct, correct. And they also, you know, they have done a great service. They have actually transformed the legal reporting landscape. And they have given us also a lot of food for thought. So we have tried to change our reporting. Because by the time people would in the morning read Times of India for some news, they have already read the thread, the live reporting thread. So they already know most of what has happened. So therefore, the push in our organizations is to be more analytical, to be more human interest based, to go beyond the order and talk to litigants or talk to the parties involved and do something extra. So that is where their contribution has been in impacting not just courts and reporting, but also journalism.
You know, as a practitioner, for me, I like them a lot because the Constitution Bench was sitting last week deciding on the issue of severability of arbitration awards and the powers of a court to modify it. I wasn't able to make it to court, but I was able to watch the thread and inform myself about some of the arguments that happened. And these websites also managed to get all the written submissions of some of the country's best lawyers and some of the best commercial lawyers, and you are able to then review them, which there wasn't, you know, I know from my conversations with you that perhaps even 15 years ago, judgments would take so long to come. Now they are uploaded immediately, they are picked up, there's a link, there's neutral reporting and things like that. So
I think the whole concept of dusty order is now gone away. Because by the time you used to in the evening wait for the order to get signed, they are all orders which get uploaded. So yes, that's true. Everything is now moving towards the electronic space. So orders get uploaded in real time. And this I see impacts the judges also. Because, you know, being a legal journalists, we get sometimes access to places where others don't. So when we go and talk to them, many a times there's a morning pre-lunch hearing, and the judge then posts the matter for post-lunch second half. But if he has made some observations and he goes back to his chamber to have lunch, and he says that those observations, he sees those observations are all over the news. So by the time he comes back, he is more aware that whatever he is going to say or observe might have an impact. So these things have basically transformed the entire court functioning, not just court reporting, but also court functioning. People have become more aware about their rights. The litigants are also following it minute by minute. So now they're not just dependent on their lawyer to tell them what happened in court. So the lawyer might come out and say, I did this and we had such great arguments, but then he would have read it or he would have seen it and he would say that, but you didn't answer this point. The judge had raised a very pertinent query. So that is how things are getting changed. So in that sense, we are far, far away from the example of Justice Clarence Thomas, which I read once, that New York Times, I think, had run a lead story in 2016 that in one matter, Justice Clarence Thomas spoke after a gap of 10 years. For 10 years, he used to sit silently on the bench. And after 10 years in one matter, he finally spoke and asked a question. So that made news. But in our case, it's pretty much opposite.
Sure, yeah. No, I think technology clearly has played a role. I think we've had COVID in the intervening years from 20 for a couple of years. COVID also transformed the way we all functioned. COVID has brought about a certain degree of dependency or reliance on technology. We now have a clear system for online appearances, and it's encouraged. Which
Paperless courts.
Sorry?
Paperless courts.
Paperless courts, which is also sort of at some level removed the centralization of court in Delhi. Because now, if an appeal is coming from Tripura, then the lawyer from Tripura can appear without traveling. And it's helped economize cost as well. I think some courts do not like it. Some courts still insist on physical presence, which is not bad. Speaking for myself, I always like to be able to see a judge, hear a judge, interact with a judge, see the body language, see the movement, as opposed to just a electronic screen. But I think, the technology has its positives, as we were talking about. But it's also, what it's done is, it's also brought about a lot of criticism towards our judicial system. There is a public opinion that gets formed on the basis of this live reporting. It's very good to see that the room is finally filling in. We started over an hour late and we would have liked to have a more full room, and I'm glad that Mr. Dhyani has brought with him a crowd. If you could all probably take a seat, it'll be great. You're all at the door. Perhaps you'd like to sit down. There's a lot of empty chairs. Thank you. But I think that, coming back to our discussion, I think that this live reporting and this whole public opinion space that gets formed has also a bit of a negative side to it, right? There is, as often we hear in courts, more in the Supreme Court, that judges sometimes get trolled for remarks. Judges sometimes get trolled for judgments because it may be opposed to public or popular sentiment. Also, everyone feels that they are now doctors of justice because everyone on Twitter says, well, they could have done this or they should have decided this. As a practitioner, I can tell you that it's very unfortunate because let's be very clear, judges do not decide on the basis of personal belief. Judges do not decide on the basis of their moral compass. Judges decide on the basis of law, what the law provides, what the precedence is. Of course, it can be distinguished. And it's therefore very unfortunate when this kind of trolling happens. And I would therefore urge everyone, in whichever way possible, that there's something called a critical analysis of a judgment. You know, we all do it, it's written about. It's good to have a healthy debate and critically analyze, but it's very, very unfortunate, and we should desist in every way possible from trying to sit on top of a judge or a judicial decision, because they are at the end of the day the best arbiter of that dispute.
True, and to add to what you're saying, Satvik, ultimately judges are also human beings. So they are also coming from this society. And similar to us, they are also affected. I mean, everybody will say that, you know, judges are not affected, but when, you know, there was a time when you and me could have been sitting in a coffee shop and there would be 2-3 Supreme Court judges, except us, maybe nobody else would recognize them. But now they are also, you know, they've been seen on YouTube, everybody knows who they are, their names, and they are being addressed as, you know, rock star judge and that kind of things. So sometimes it also affects them. Now they run the fear of being mobbed if they go and sit somewhere or step out in public scrutiny. So yes, that is a bit unfortunate because they would like to be known by the judgments they author. Absolutely. And by the reasoning given in the judgment, rather than by their demeanor or by the oral observations that they make during hearings. So, but I think it's a genie out of the bottle. I mean, we can't reverse it. So as Justice Chandrachud once said that, you know, you have to get used to this and you have to find your own ways to how to deal with trolling, online anonymous trolling, and how to respond to that by being more disciplined, disposing more matters. Because I believe that till now, you know, the judiciary, the only actually heel it has is the delays and the long pendency of cases that they have. But now, because people are seeing more and more court proceedings, they're hearing more and more judges speak. So somewhere down the line, there's a kind of too much familiarity happening with judges, which, you know, somehow the aura, it's affecting the aura of the judiciary. Because then people say, oh, they are people like us. You know, they also have this problem, they also get angry. But as I said, the way to look at it is, the way to analyze it is through their judgments, not their, you know, individual idiosyncrasies or individual habits or the way they speak or the way they may address questions. Ultimately, the judgment that they have authored is what should be put under scrutiny and analyzed.
Yeah. I think in the interest of time, not to run over, I think the real draw was not so much the session as the sandwiches and chips that brought people into the room. So next time we should keep the sandwiches here earlier. So I was beginning to feel elated at myself that people were probably coming to listen to Abhinav and I, but it's the draw was the sandwiches. But, to make sure that we don't run over, I don't know if there's any questions from the audience. We're only taking questions on law, not about the quality of the chips or the oil medium that they're cooked in. So, yeah, please.
Hi. I always wanted to ask this question to a journalist.
You're not audible.
I always wanted to ask this question to a journalist. And now when we have a journalist as well as a lawyer on the dais, it gives me more pleasure to ask this question. When we do the legal reporting, as you rightly said, that there are some misinformation, elements of misinformation which is out in the market. People are trolled. People are judged for what they have done or what they have not done. There is some misinformation even before the judgment comes in. Now, I would like to hear from the horse's mouth. The third pillar of the democracy and the fourth pillar of the democracy both are sitting here. I would like to ask from them, should there be an accountability set for the journalists, especially the legal journalists, when especially in the cases, the sensitive cases wherein the lives of people are at stake, the reputation of people are at stake, and a little bit of misinformation can bring about a devastating effect.
So can you specify some example?
You yourself quoted some examples in the actor's death case and the actor's arrest case and even Shah Rukh Khan's case and all.
Yeah. So as far
and
as
even in Jessica Lal's case, there was some Nitish Katara's case. There was some misinformation which was there in the market, and there was some element of forcefulness which was there, which could have turned the case on the other side, or which could have influenced the matter. But it was for the lawyers that... Yeah.
Keep the question short.
So I've already completed the question. Whether there should be an accountability set for the journalism, especially on the legal areas where the misinformation should stop spreading.
See, you gave 2-3 examples, so let me clarify. As far as Jessica Lal and Nitish Katara case were concerned, the problem was not with us or with the journalists. The problem lay in botched up prosecution, in forensic evidence not being dealt properly, in ballistic reports being changed. So the problem was at the end of the prosecution, at the end of the state. It was a polluted prosecution that took place, which resulted in acquittals. And maybe there was some over-enthusiastic reporting that happened, but the end result was that justice was done. In the other cases that you refer to, the issue is that there's always the option of the accused or any affected party to approach the court, to approach the police, and lodge a complaint that this kind of a media trial is happening, and and because of which we are suffering. So please put an end to it. And courts have done it. There have been gag orders passed where you can't report a single incident or event about the case as long as it is sub judice. And there have been in-camera trials where nobody is allowed inside, nobody knows what has happened till the time the eventual verdict is out and the verdict is read out, and then you can report it. So as far as for print and television journalists, this aspect is always available. This solution is always available for people to go to court. And then we have our own national the Broadcasters Association and the Press Council, which is there, which also has mechanisms which can be used. The problem lies in when there's misreporting and the camouflage of freedom of press is used to sort of get out of it. But at the end of the day, I think Satvik would agree that it is the available mechanisms available remedial measures that are there, which have to be used by anybody if they're aggrieved by, so to say, reporting of a case?
So, sir, as a law student, I often write articles, and as a law student, I often write articles, and of course, I've learned the art of article writing from Satvik sir himself. When he last year advised that there should be a conclusion in your article. Now, what I am writing may not have a legal effect. It cannot be, I cannot be sued on that possibly. But if I write something on LinkedIn and in that conclusion to a particular, maybe an order passed by the government, I put on some kind of an opinion which may, in my view, form a part of the conclusion that I am concluding. So in that case, how can I draw that line where I may not be sounding biased and as well as I should have my own opinion expressed as well? If you could if you understood the question.
Yeah, so, I'm happy to take this question outside. We're both happy to take this question outside. I think it's not so much on the topic of legal journalism and its interplay with courts. But the short answer to your question is that if, let's take for example, there's a judgment, you are free to analyze the judgment, you are free to provide your critique to the judgment, which is sometimes even in reporting, there's something called fair reporting. It's a standard, it's a measure, and there's something called fair critiquing. The whole objective is that you can't deride a judgment. It is eventually the rule of law. You can say the court had this evidence and it should have considered X, Y, Z, and maybe if it had considered X, Y, Z, it could have come to a different conclusion. But the objective should always be to see if anything got missed and how it could be better, rather than only critiquing it. It's like, if your mother's made you paneer ki sabji, you can say कि माँ ये पनीर की सब्जी अच्छी थी, थोड़ी सी मिर्ची ज़्यादा थी या थोड़ा सा मटर कम डालना था, rather than saying ये तो बिल्कुल ही खराब थी, आपको तो पता ही नहीं. That's not the way. So it's how you canvas your argument which matters. If there's no further questions, then Abhinav and I can go enjoy our cup of chai and call it an evening.
Yes, I think so.
On a parting note, yeah, you have a question? Yeah. Really quick, because we want to make sure that we don't run over in terms of time.
Hello, sir. I'm an advocate practicing in Delhi High Court. I really appreciate all the insights that you have shared. At the same time, I would like to ask these questions that often we see, even before a case is actually reported, means actually is coming before the court, it gets reported. So-and-so PIL has been filed in the Supreme Court. So-and-so application has been filed. So now, of course, Supreme Court judges have also pointed this so many times that without coming before the court, so-and-so application or petition, it gets published in the media. Now that is an effort or attempt to kind of influence the judges or like creating sensationalism in public. So who is actually to blame here? If it is not media, who else it is? Because it is supposed to be between two individual private parties. How is media getting access to it? That is not an issue. How they are actually reporting some specific portion only to create an issue, and that is like regular basis it is happening.
Yeah, so I think what I have understood from your query, so it's hardly maybe once or twice the case may be where it is between two parties. One of the parties would either be a department or a government entity or police or CBI, or this National Investigating Agency, that kind of a party, and the other would be an accused. Otherwise, if it's a civil matter, then there would be organizations like some government ministry or Delhi Development Authority. Most of the time, the cases are of some or the other type of public interest, which is why every new document filed, every status report filed, every affidavit, every counter that any department or the petitioner files in court, it becomes news because it takes our understanding of the issue a little further. And there, on one ground, you're right. Sometimes I've seen judges get very irritated when they see that what they are supposed to open or see during court proceedings has already been reported. But that, I think, is a risk which is for the lawyer to understand. Ultimately, it is the lawyer or the person from the department or the petitioner lawyer who shares all these documents with journalists. So once we get a document, we don't have any obligation not to publish it or to wait for court proceedings to happen before publishing it. I, as an individual journalist, I usually follow the rule that, if a sensational PIL or some a PIL making sensational claims is filed, I wait for the court to hear it, to issue notice, if at all, and then I report it. So there, on that aspect, you might be right, that the problem is there.
Right, sir. Thank you, sir. At the same time, sir, there are also...
Let's, no follow-up question, if that's okay. I just want to, on a parting note, say that both Shrish and Vikash have done an excellent job. I was here at Vidhi Utsav last year, which was their inaugural seminar. My heart swells with great joy and pride seeing such an illustrious list of sponsors and collaborators of the Vidhi Utsav. We've also had a absolutely stellar line of speakers yesterday. The former Chief Justice of India, as Shrish was sharing with me, opened the Utsav and almost got mobbed with 900 people. So all I can say is more grease to your elbow. I hope you both prosper. I hope that you guys have a great continued series, and here's to your continued success. Thank you for having me here, and thank you for joining, Abhinav.
Thank you so much. Thank you so much for inviting.